because with EEOC, you only have 300 days. That's less than a whole year. And so if I don't waste 9 months over here in this other venue, I really don't have time to now bring my claims in another venue. And the 300 days is calculated based on your harm. So if your harm was termination and you got terminated 9 months ago, you're pretty much up against that wall. And if you waited all this time in the wrong venue, it can be very harmful and you really don't have an opportunity to bring your claim anywhere else.
Welcome back to Impostrix Podcast. My name is Whitney Knox Lee, and I'm your host. This is Season 3 of Impostrix Podcast, where we are focusing on validating small business owners of color, entrepreneurs, and folks who unfortunately are navigating employment discrimination in their workplace. Impostrix Podcast always puts folks of color first. So all of our guests are people of color who are sharing about their personal experience or their learned experience. So buckle up, let's go. Hi, and welcome back to Impostrix Podcast. My name is Whitney Lee. I am your host. I am here today with attorney Chiquita Hall-Jackson. I look forward to this conversation because we are going to be answering quite a few of the questions that I've been asked by listeners and by friends. As you know, I am not an employment law attorney. I do handle race equity consultation and coaching. I work with people who are experiencing racial toxicity within their workplace, but I do not represent people in suing their in suing their employers and holding their employers or others at their workplace accountable for harassment or discrimination. And so I try not to comment on whether or not somebody's experiencing discrimination because I don't know. All I know is that if you are feeling like you're in a toxic work environment, then you probably are. And we need to take some steps around how you're going to navigate that. But whether or not you can hold somebody legally accountable or liable for that is another question. And so that's the type of question that we're going to address today with Attorney Hall-Jackson. So I appreciate your being here. Welcome to Impostrix Podcast. And please introduce yourself.
Hi, I'm attorney Chiquita Hall-Jackson of Hall-Jackson and Associates and Blow the Whistle Law here in Chicago, Illinois. I fight on behalf of workers every day who have been faced with discrimination, harassment, or retaliation in the workplace.
Awesome. And do you have any other identities that you want to share with us that you're bringing into this conversation?
I also serve as a consultant and DE&I expert to go in and train corporations, organizations, and associations on how to navigate the workplace and just different roadblocks that we have and how to effectively communicate. Because I do believe that that's one main issue why we face what we perceive as discrimination or some kind of bias in the workplace. While we also are being passed over for a promotion, is not getting promoted at a rapid rate as our counterparts because we're not opening our mouths to say we want these things. So as a result of all of this, I try to educate people as well. So from time to time, I host webinars, and I also wrote a book, We Gon Be Alright, Black Executive Guide on how to navigate workplace dynamics.
Ooh, nice. Okay, I'll make sure to link that in the episode description so that folks are able to access that and order a copy if they would like to read it. So do you handle more of the compliance side when you're doing DEI stuff, or are you also handling more like relational stuff?
One more time.
Compliance, do you handle compliance aspect of DEI work?
Yes, I do apologize. Yes, compliance on the compliance side, how you can comply and be integral and honor the statutes and rules and policies around it.
Okay, awesome. Thank you. How did you get into employment discrimination work?
I got into it ironically. I had a college classmate reach out to me. Her father had brought a case in OSHA, and he believed that he was being retaliated against, and he also felt there was some age discrimination as he had, out of 20 plus years in his career, had one code violation, aka a policy violation, while working on the railroad, and he had given them over 20 some years, if not close to 30 years of his life. And this is the first time. And instead of them giving him a warning, whether that was oral or written, or even a suspension, they moved for termination. But ironically, he had previously complained of some safety violations that he felt like the company was in violation of. And so as a result, he felt like he had a whistleblowing case. And because it was safety issues and it was around the railroad handling, he ended up going to OSHA and not the EEOC. He got himself as far as the hearing. And so when he got his actual hearing date, my classmate reached out and said, there's no way my dad can represent himself at a hearing. It's like a trial. And I refused to let him go. Can you assist? And then at that point, I was like, okay, I'm willing to assist. I got in and did, and I really enjoyed it. And then fast forward, another classmate from the same university reached out. Her aunt was going through a workplace discrimination, hostile work environment, and it got so bad that it messed up her mental health. And they really wanted to come together as a family and help this young lady, and they did. And she ended up retaining, and it was like one of the most heart wrenching cases that I had because this young lady attempted to try to cut her face to make herself unpretty due to the sexual harassment that she was being subjected to in the workplace. So she just wanted to get,
Wow.
she cut all her hair off, whatever she can do to disfigure herself so that she can stop getting the touching, the comments, and the harassment on a daily basis. She had navigated this process herself and went to the EEOC mediation once by herself. They reduced an agreement to writing, and things just got worse once she returned back to the workplace. So after that, I just got on this path to like help workers, and every time those cases came in, it just was like, okay, I got to take these cases. I got to help these people. Then I realized it wasn't many people that looked like me, but the people that was being served were a whole bunch of people that looked like me. So I'm like,
Yeah.
definitely, this is my lane. It's where I need to be. And so in 2017, I announced that effective, I think January 2018, that we was going. If it wasn't January 2017, it's January 2018. But we was going to go full employment law, and we was going to stop all other practice areas such as family law, criminal law, and a few others.
Okay. So you mentioned a couple of terms, abbreviations that our listeners may not be familiar with. That is OSHA and EEOC. And I know that these are two federal agencies that oversee some of the conditions or our experiences that we're having at the workplace. But can you break down what is OSHA and what is EEOC? And when would you go to one instead of the other?
Sure. So OSHA is, if you Google it, OSHA is Occupational Safety Health Administration, if I'm not mistaken. But ultimately, anytime you're in a workplace and you feel like that you're not safe, whether that's kind of because some hazardous materials got leaked or a substance, chemical, or something like that. Also, you're not being provided with the proper PPE. I'm about to say PPP, but
Mm-hmm.
PPE,
PPE.
yeah, which is the equipment that you would need to operate your jobs. Whether if you're in the nursing field and you feel like you should have gloves, masks, and different things to protect yourself, if your job is not doing that. Also, if you witness some abuse and different things like that. So that's what more so OSHA is for. The EEOC stands for the Equal Employment Opportunity Commission. And what they do is they focus on discrimination, and that's who receive most complaints across the board as it relates to workplace, because a lot of people notice on the bottom of their application that said that this application in this position is governed under the rules of Equal Employment Opportunity Commission. However, a lot of stuff people fail to realize that you have to have not a racial component. You have to have a discriminatory component to it, and that could be your race, gender, sexual orientation, religion, disability status. Some group or someone has to be being treated better than you, and as a result of that, you feel like you're being less favored, and as the harm has resulted as you being treated less favorably, and so then you will go to the EEOC and bring your charges and claims.
Okay, so what is the legal regulation that houses these racial discrimination or other workplace discrimination claims? In case somebody wants to research, like, am I being discriminated against? What are the regulations that they're looking for
Say it one more time. What are the regulations that EEOC they're looking for, or OSHA?
at EEOC?
So as far as what they're looking for, exactly what I explained, you have to have someone being treated better than you, and that's a good question because I see so many people they get upset because they get these unsubstantiated claims and unsubstantiated findings because you're technically in the wrong venue. So the key component is to look out for, is this a personality conflict? This person doesn't like me because I wear straight hair and they wear curly hair. I'm always dressed up and this person is dressed down, because I get it all the time. She doesn't like me because I like to get dressed up, wear my lipstick every day. I like to, come in. My appearance matters to me. But someone else, it might not. And so that's more of a personality conflict. Some stuff that you would hear your children come home and complain about what's going on, like bullying in school. But unfortunately, that is not protected by the law. There's no bullying laws out there right now for workers, and we have been pushing for them. But unfortunately, the court understand that they will be flooded, because it is people
Mm.
who I like to describe as the devil wear Prada attitude, where they're just nasty and mean people. And if they treat everybody the same, then there is no discrimination. They're just a nasty person. So outside of having a different protected class, again, that can be your race, gender, sexual orientation, religion, disability status, you also have to be meeting your employee's legitimate expectation at the time in which the harm happened to you, which simply means that on average, once you get your performance review, you are graded as an average or above average type employee, and that you're not this heavily disciplined type employee. And then the third component, they look at adverse action, which is very key here. A lot of times, even with the discrimination, they're treating this person better than that. But what is the harm? So we actually, is it called adverse action? What is the actual harm that happened to you that a judge, jury, or an attorney can gauge and touch? And usually that is some kind of monetary value. So I'll give an example of failure to promote. If I'm a black female who has been passed over for like 5 promotions back to back, and I'm noticing they're all going to my white male counterparts, well, I definitely met the component of I am a black female. So that's the protected class. On average, I have maintained a great performance. And then three, this person has been passed over for me, thus I have been denied the promotion opportunity. Now, what it boils down to is the fourth element, and that's usually the hardest element. You want to compare yourself to someone else, and I will be comparing myself to the 5 other gentlemen, white males, that have actually been promoted over me. And as a result of these promotions, I want to show that I was a better educated and better qualified individual, or we was at least similarly situated, and that we should at least both have given the opportunity to interview. And so the fourth element boils down to how is the person outside of your protected class, meaning someone is the opposites of your race, gender, disability, and age, younger than you. How are they treated better than you? You have to be able to articulate that, and so many people cannot articulate. They cannot even identify a co-worker who received the same or similar treatment but was not punished as harsh or was given better treatment. And so that's the hard part when you're talking about
Right. So
performance.
there has to be that comparison.
It has,
You have to be treated differently, and you have to be able to show that someone else was treated perhaps better than, or more, they had some kind of benefit that you did not get, and that you think is based off of your protected class.
yes, yes, yes.
Okay. So once somebody has determined that they are experiencing what they think is racial discrimination or harassment, what what is the very first step that they should take if they want it? And I guess let me clarify this question, because we do need to acknowledge that there are different things that people might want. Some people might just want for it to stop. They want to be able to work there in peace and be able to make their, salary, or their pay, get their paycheck, and keep it moving. Other people may want to hold the workplace liable. They may want to sue the workplace, but continue working there. Maybe other people may want to leave the workplace but be provided some type of severance agreement. So I think in terms of, if you are somebody that has tried to get the harm to stop and that has been unsuccessful, what are the next steps that you might suggest somebody take?
And so in most situations, it depends on who are you actually reporting this harm to. There, my biggest thing with employees is going back to that employee handbook. I know we got it when we first got started. We throw it under the desk. It's allowed and given to us in electronic format, so I rarely go to it. But if you're looking at employee handbook, it should give you a roadmap as to who you should be reporting to. How do you report up and internally? And if you have went through all those channels, because if it is your supervisor, you don't want to go complain to your supervisor that you're uh, harassing me. So do you go to your supervisor, or do you go to human resources? If there is no human resources, who do you go to? And so after you have complained internally and you have documented this via text message or email and nothing is being done to help you and address these concerns, then you want to reach out to the third party. And I would always say consult with an attorney and get a consultation if you can to get some kind of guidance as to which venue will properly be best, because that's another thing. You might can go straight to these venues, but I have known people to file with every venue under the sun only empower the employee because you're going to get a lack of substantial finding and they're not going to rule in your favor. And so now the aggressor is now going to feel empowered that they have just won a whole nother alleged discrimination suit. And now they're going to retaliate after you and just become worse in most situations. And so you definitely want to take the time out to reach out to an attorney and consult them. And most have offer free consultations or a nominal fee to get some kind of feedback on that. But to answer your question without the attorney, you can always determine which venue is best for you. And if you're talking about I'm not getting my wages, I have complained about my wages. There's departments of labors in each state. There's also federal Department of Labor. If you're complaining about your union, there's union organizations and venues administration that listen to those claims. So it's all about which venue, but you would definitely decide to now move this to a third party, aka an external agency or department to report to. And the easiest one that everyone know is the EEOC. But again, that's only if you feel like another group is being treated better than you. If it's a safety issue and you're not being heard over and over again, then you want to go to OSHA.
Yeah, thank you for that clarification. So when you're saying venue, because again, non-attorneys may not know this language, we're really talking about where are you going to bring this complaint? Which or not organization, but which federal agency or which state agency are you going to seek help from, if you will? And I'm glad that you brought this up because one of our other guests on the show this season um, was in California and experienced what he thought was harassment and was trying to navigate this process on his own. Ultimately, my understanding was that he did reach out to the wrong venue. He was referred to the other, appropriate body, and then they were able to go through that process. But getting that, this isn't substantiated, was really demoralizing for him because now he's being told, or at least what he's understanding and what others are understanding when you get that basically reject letter,
Yes.
is that your concerns aren't valid, which isn't necessarily what they're saying. They could be saying that. Um, or a matter of fact, they probably aren't saying that at all because they're not the ones to even evaluate it. What they're saying is this is the wrong place. Um, so for folks that may be familiar with like criminal and civil law, that'd be the same as filing like a civil complaint in criminal court. The judge would deny this, complaint because it's just improper. It's not supposed to be filed in a criminal court of law. It's supposed to be filed in a civil court. That judge can't hear it, and so you wouldn't be able to move forward. Similarly, here in the employment law context, if you are filing your complaint in the wrong place, you're going to get a notice saying, in some language, some terms, that this isn't the right place to file it, and that can be demoralizing.
It can be. And again, it like you said, internally you internalize that you did something wrong. And then again, and that's my point of educating, because people always like, as an attorney, why are you out here giving people this juice, right? But my thing is, the more what attorneys thrive off of and what we rely on is making arguments based off precedents. aka prior case law, and cases that came before my case, and that can actually say that this was the jury verdict, or this was the court's ruling and decision, this was the EEOC ruling or prior whatever agency ruling, and this is the dollar amount that they put out there. But if we got a whole bunch of bad cases that my defendants can rely on and say, well, a similar case was thrown out for the same reason, y'all need should follow the same case, versus we have so many of these cases where they were successful, and here's what we can rely on the plaintiff side, aka the complainant side. It's hard for us to continue to navigate and fight on behalf of workers, and so many of my colleagues are leaving and go to the other side of the V. And you have to realize it's because we gotta know which cases to bring and why we should go with this venue over that venue. And another key component outside of the humiliation and embarrassment is the safety net of timing. Was this person timely by the time they got the lack of substantial finding, or you in the wrong venue notice? Because with EEOC, you only have 300 days. That's less than a whole year. And so if I don't waste 9 months over here in this other venue, I really don't have time to now bring my claims in another venue. And the 300 days is calculated based on your harm. So if your harm was termination and you got terminated 9 months ago, you're pretty much up against that wall. And if you waited all this time in the wrong venue, it can be very harmful, and you really don't have an opportunity to bring your claim anywhere else.
So let me ask you, because you had mentioned like the bullying component of what people are experiencing in work, and that sometimes does not rise to the level of discrimination because maybe there's not that comparison piece where you're being bullied because of your protected class and you're able to show that somebody not in that class is being treated differently. What are some examples that you have, like, I guess, cases that you have represented an employee that were discrimination? What are examples of like that fact pattern?
So instance in which I did represent employees in the race discrimination case.
Right.
So the most recent one that I can think of, we get that's the majority of our cases, but the most recent that I can think of is and the most common is we get African Americans, whether that's male or female, but majority black female who have sat in a role for years, and they are actually applying for promotions but are being denied the promotion. But when the promotion is granted, they're noticing it's going to the same demographic, whether it's a white male or a white female, but they're also being required to train these individuals. So they're
Mm.
now required to go in and train you for a position that you told me I wasn't qualified for and that I didn't get. And so, how do I navigate that? But it's so many people that's just sitting there for years, that's going through this, and then they get to their breaking point. After this is the fifth application that I've submitted and I didn't get, and you're yet asking me again to train someone. Or this person sat in the acting role or the interim role while the role was unfulfilled, and I performed all the duties, and I was more than qualified to serve in this acting role. And then when it's time to actually fill the position and pay me for my work, then I'm not qualified and it's given to someone else. So that's one case most of the cases I often see in this. Another one is you have someone subjected to racial slurs, and you might have someone who's in the workplace where they're noticing that attendance policies are being, or any kind of policies is being bent
Mm.
for this particular group. But when it comes to me or other African Americans, the policy is strict by the book. And one of the most successful cases we had was a young man who he had this was a different railroad. I actually got this case from the first guy's case, but he worked for the railroad too, and he was a conductor, and him and the engineer was chopping it up in a little booth, and they was talking and actually missed the red light signal that was coming to tell them to slow down. And so when they saw the red light, it was full. All the warning had went back, so they hurry up and hit the brakes real quick. He wasn't even a guy responsible, but they triggered the black box on the train, which ultimately goes to headquarters and let them know something is going on. They didn't cause this derailment. They didn't cause any harm to anybody, but ultimately they alerted the red box, and of course, the company focused on hypotheticals of what could have went wrong, and as a result, they end up terminating him. They didn't again give him a slap on the wrist, anything like that. But luckily, through the rumor mill and by him having so many years on the company, he knew several other people that did the same thing, and they just got a oral warning, slap on the wrist. Again, this was one of his first violations as well. And so, of course, being a few black people in the workplace, they all rallied together and they started telling their stories. Like, I remember Sam Smith did the same thing. I remember John Smith did the same thing. And so they was able to, in discovery, we was able to gather and provide opposing counsel a list of names, and we asked for all their personnel files. And of course, they objected, so we was able to limit it to their disciplinary records. And once we got all these people with disciplinary records, anybody that was non-black, but mostly white males, Hispanic males, and a few females as well that was not black, we noticed that these people had actually caused, a few people had actually caused fatalities, aka somebody has died because of the same response. Hurry up and dropping that break at the last minute has caused derailment, or somebody was trying to beat the train and I hit the brake too late and caused death and things like that. And these people simply got a slap on the wrist. They did not get termination. The judge felt that that was so wrong, and the clear version and direct evidence of discriminatory practices in the workplace. And this guy was successful on trial. And so those are the type of discriminatory examples you we're looking for when we do intakes. How what is being done to this group over you and your group of protected class to make you feel that you're being treated less than and they're being treated favorably.
Thank you. I have like so many questions have come up as I've been listening to you talk, and you mentioned your intake process, and I know that you're just one attorney out of a sea of attorneys who handle these types of cases. But when someone is reaching out to an attorney for assistance, yes, they're going to give you their written or oral account of events, but are you also needing some type of documentation to support what they're saying, to determine whether or not this case is a viable case, or are there other what is the process?
So yes, we do. We have people come in, and on our website it says free consultation. You can click on that link and ultimately fill in a questionnaire. We ask you a series of questions to qualify you, and then from there you will set up a call with our intake specialist, and they will pick you back and ask you a series of questions to kind of flush out the scenarios of what you're providing and determine if there's something there. And then after that telephone conversation is concluded, then we ask for actual supporting documents. So in most situations,
Okay.
most people call us once they're terminated or suspended. So we want to see that suspension letter, that termination letter, um, any witnesses' names and contact information that you possibly know witnessed these situations, any statements, reports that was given. Um, Another thing we look for, if there is any emails or text messages that actually support and substantiate what you're alleging happened. This guy called me this N word on this date. Was this via text message? Was this email? If not, this was orally. Was anyone else present besides you? Are they willing to speak up on your behalf? But those are the main things. Also, a company handbook. We also like
Mhm.
to see if you can get it to personnel record. We usually want that more so when we're ready to represent, but it is helpful we can get it beforehand because people like to be the ideal employee, but your handbook might say something. I mean, not your handbook, your personnel file might say something else. And that's one of the key components where what kind of employee you was, because of course that's going to go to the defense side that we didn't give them a promotion or we didn't allow them this opportunity that we allowed someone else because of their performance. They were more
Mhm.
so on a probationary period, or we wanted to monitor their performance a little bit longer before we agreed to allow them to work remotely while we let John work remotely. John has not broken our trust, but they have. So we want to know all that up front before we can say yes.
Yeah.
Because I would hate to take your money and then I get your personnel file and it's like, oh, well, you didn't tell us this key component, and this kind of justifies why, especially when you get the defendants involved and there's going to be their written response, then we need to be able to get in front of all of that.
Yeah, because it sounds like your disciplinary history is going to be a big deal. Like, as far as in the workplace, if you have previous warnings, or if you've been disciplined in the past for your work product or your work ethic or whatever it is, that is going to have an impact on whether or not your later claim can actually be a viable claim. Is that
Correct.
right? So I'm wondering about, if I am coming to you as someone who has tried to resolve issues within my workplace,
Internally.
that has not resolved the issues. So now I'm seeking an attorney for representation. Uh, what steps are you taking in that representation? So is there, like, first some kind of communication that you send to the employer to try and work it out informally? And then if that doesn't work, are there other things that you do before you're getting to trial?
So yeah, if you yeah, we definitely send demand letters, aka a correspondence stating that here's a summary of the facts from what we understand it, and that we are threatening a litigation, and that we're going to move forward with the following steps to bring this before litigation, aka before a jury, trial, judge, or before administrative agency. And in order for us all to save time and resources financially, um, and mentally, because it's a mental toll, um, we are demanding X, Y, and Z. And then there's the, they're either going to reject it completely or they're going to entertain it and maybe counter back and forth. And so then we go back and forth on that to determine what can be done.
Okay. And if they reject it, then what's next?
Then we just move forward with the steps that we threaten. And more than likely, that means administratively, because in most situations, you have to start with an administrative agency and then they'll give you a right to sue, or their appeal process would include you going into a court of your choice based on the jurisdiction.
Okay. So is it like you file the complaint with the agency either determines, like, is the agency determination that this may be discrimination or it is not discrimination? And then from there, if it's a maybe, then you're getting like a right to sue letter?
So in most situations, regardless if they say, well, across the board, regardless if they find in your favor or not, they usually give you still the permission to go sue, because it may be that we didn't. Mostly what it is that they're not necessarily guaranteed that they did a full pledge of investigation, meaning
Yeah.
that
Okay.
although you may provide us with 10 witnesses, we might not call even two of those witnesses. Our resources are limited, our team and staff is limited. So you just haven't been in our portal long enough where we might just be at this point trying to clear out things. And so
Hmm.
unfortunately, we cannot say either way or not. I have had it where they actually break down, here's how we investigate, and unfortunately, we just don't find in your favor. We get those letters. If I, as the attorney, feel like, despite them not finding your favor at this level, I feel like if we get the right discovery in court, aka the right evidence, the access to these personnel files, and a few other things, that we will be successful. So I still would take the case, and we have been successful. Although the EEOC might rule one way, we was able to get a success on in court. Then there's times where the EEOC has substantiated the findings, and you still could take that to court. So it's, to answer your question, regardless of how it is, it's a part of the appeals process. The same thing if you lost
Okay.
your job and you went before a hearing officer, and you don't agree with that hearing officer's ruling that they should uphold your termination, you would appeal it up. And so that's just another way to appeal it.
Okay. And is the ultimate appeal done in a state court or is that done in an administrative agency?
With the state agency known as the Illinois Department of Human Rights, and there is other departments of human rights or human rights commissions within various states, they will give you the right to sue in the state court because you brought it before their state agency. And it could be also an opportunity for you to appeal internally through their appeal process, and they have a commission, aka a panel of judges, who that you can now appeal, and you will still go through this discovery process. It's like a trial and court proceeding, depositions and all that different stuff. You have a right to go through that. That's the free venue, but there usually is a backlog, and then you also have to realize, how do these people get these jobs? Conservative bench versus a liberal bench, all this different
Yeah.
stuff. So your chances are kind of slim there. But a lot of people, because they're trying to navigate the system without attorney, they usually do that. But you're talking about 5 years just to get this ruling and get through this process. Um, because it's a free agency and their resources are limited. But you do have a right to go internally apply and appeal through their internal. And again, they have a panel that will hear your cases and different things like that. And then you have the option, so state court, appeal it internally. And so those usually your options, or you can just leave it alone. Or within that state, you can ask the EEOC to do a subsequent review of what the lower court did. And then an EEOC, if you now go from the state agency to the EEOC, they give you a right to sue to go into the federal courts. So again, if
Okay.
you want state agency, you get to go to the state court. If you go through the EEOC, you get access to your local federal court. And then all agencies allow you to appeal internally through them.
Okay. Yeah, this sounds really complicated.
Yes.
This sounds like something that if you are experiencing discrimination and you're at the point where you've done all that you think that you can do internally your employer, within your employer, uh, that seeking an attorney or an advocate would be really helpful,
Yes.
because this just seems like a lot to navigate, and especially considering the timelines, the deadlines for filing these complaints.
Yes, and that's the biggest thing. You don't want to blow your statute of limitation. I often go out and I did I'm an attorney because the conversations that's flows when I'm out just trying to have a good time and leisure, right? But when I do engage other people and let them know I'm the attorney, I got that cap on, I hear some of the best stories that would make some of the best cases that happened years ago. And unfortunately, the statute of limitation has passed. And at that point, they never did reach out to get counsel, and that 300-day has passed.
Hmm.
Other statutes of limitations, if you want to consider bringing it other ways, have also passed. So unfortunately, you have blown that. So if nothing else, I think, like I said, you can reach out to an attorney, at least find out or Google what is the statute of limitation, how long do you have to bring certain claims.
Yeah, thank you. Okay, I just got two final questions. Um, Both, I know that my audience are like, okay, Whitney, when are you going to ask like how much this stuff costs, or how, how do I make this work financially? So my first question is around the fee structure for employment law attorneys. Is it typical? What I understand being in the profession here in Georgia is that employment law attorneys, similar to like personal injury attorneys, is standard to take 33% of any cash or monetary award. Is that the case or no?
So that's a partial case of it. So in most situations, there is a contingency on the back end where the attorneys are looking to get a 33 and a third percent of um, I'm sorry, 33 and a third percentage of the, like you said, award, cash award, whether that's a verdict, a settlement, or whatever. Meaning the settlement means that you and your employer agreed to get rid of this before a ruling was made, either way. And so we'll get a percentage of that, aka the standard is 33 and a third. It's some people that may charge a little bit more, but average it should be 33 and a third. And then there is certain attorneys, including my office, where we want a retainer up front because, as you can see, these cases can take years. And so the idea of a payout, and then I'll give an example of a horror client. I had a client who I had advised several times throughout the course of litigation that I felt like uh, he's not going to be able to move to the next stage. And that I think this is the best it's going to get because he had a comparator. And technically, he only had really one comparator, and the defendants accidentally gave us that in discovery. They didn't even know it was in there till I brought it up in the demand letter, and she was like, "What do you mean? What? That's not true." And so then she's like, "Oh, she noticed it." So we
Yeah.
with that, it kind of raised the bar of how much they was now trying to put on the table. But I'm like, technically, it's not apples to apples, meaning that the behavior in which he was cited for, he was driving on a suspended license. This person was driving and had a history of known DUIs. Now, granted, the regular layperson here, they're like DUIs, that's dangerous, and he was a driver for a company. You definitely would think that would be the worst, and it's worse than driving on a suspended license. But here's the thing: he made the company aware of his DUI and his alcoholic problem. So they was able to coddle him and put him in different programs and put him in the driver's seat, the passenger seat, and mandate that he always work with another technician. They had to ride together. So he did more of a ride along. Versus this person, they pretty much the company found out. Now there was a company policy that if you didn't find out and tell us, he didn't know that he was driving on a suspended license, obviously with a driving role. But if the company find out and they informed you by a random drug, they didn't even think they do random drug tests. They did a random driver's license check, and that's when they found out. He found out they did have a system to cure it, that if you find out and you didn't tell us that here's what you can do, he was supposed to be offered the same privilege as to having a ride along until he cured it. He found out on the Thursday or Friday. By Monday, everything was cleared, and he should have been able to go back to work. Unfortunately, as a black man, they didn't provide him those opportunities and grant him that. So it's definitely some discriminatory practices. But he had to have the burden of showing the judge that the two was a comparator and that he was treated better than him. And unfortunately, the judge. Now we got past a motion for summary judgment, which is a motion that the last motion before trial to allow you to get it, and we progressed. And I was shocked, and I'm like, okay. So ante up in the eve of trial, I'm telling him like, this is the best we're going to get. I cannot guarantee you this. He had over $300,000 on the table. This man decides that no, I want $300,000 in my pocket. Get to trial. The judge did not. Now, granted, we did our thing, and the judge was telling the opposing counsel he gave it. The judge was new. That was another thing I was trying to warn him. I couldn't call a colleague and say, "What about this judge? What do you know?" It was just so many things up against this guy, and I'm telling him. And unfortunately, the judge ruled against him. You've been in
Wow. So
litigation.
was that zero then? He got $0?
$0, and I'm as the attorney dependent on a percentage of that. After
Yeah.
I put my time and resources putting the trial together, getting documents, copies, paying another attorney to come to trial with me, all this stuff, and so we both walk away with zero at the end of the day. But you have he put like probably a very nominal retainer when I was first, in this, but he had been in
Yeah.
court for over 5 years. So that's why I give this story to say why we charge retainers, because a lot of people, I want an attorney, and then they tell you, and I even put in my fee agreement that you're gonna go off the advice of your attorney. We also charge additional fees now because of this one case. That if
Mm-hmm.
my advice to you is that, and it's not that I want to get this done without doing the most work that I could possibly do. Believe me, as a trial lawyer, I want to get dressed up and go to trial and have so many trials under my belt, and I need that to go to the next level. If I want to become a judge, we need so many trials under our belt. But we also know when this is probably as good as it's going to get, and if you can't take that advice, and especially when I'm telling you, you're very close to what they will owe you on your best day. Do I take the risk? All trials are 50-50.
Right.
And so with
Right.
that, we have a lot of us now. Some people might still be out there doing straight contingency, but in most situations, there isn't. And in my office, we take a retainer up front, and then you have to give a 33 on the back end.
Okay. Okay. Um, yeah, I can't tell you how many times what's frustrating as an attorney is that your client has come to you as the expert, as the advocate, to help them win their case, but then they're not willing to take your expert advice. And so that is definitely something to keep in mind for folks who will end up reaching out to an attorney regarding an employment law matter, or any matter really, is that we understand that you're very close, you're very passionate about the situation, you experienced a harm, and it means a lot more to you than anything anybody's ever going to offer you.
Yes.
And you hired us as the attorneys for a reason. And so, like, listen to our advice.
Yeah, and then the crazy part, I always tell the judges, because they do give you an opportunity, whether you're in federal court, state court, or whatever venue, to go to mediations.
Mm.
And I always encourage a mediation regardless how far the parties are. If my client is up here in the sky saying I want multi-million dollars and the defendant's down here saying we only got a 5-figure offer for you, I still encourage it because I want my clients to hear from someone other than myself that I'm not pushing you so that I can get some money and get this case over with. I'm pushing you because I'm evaluating the case based off my experience and my knowledge and my research around these facts. And I don't think you're going to survive the next step. So let me get someone else to tell you
Yeah.
that has no involvement, no
Right.
emotions attached to this thing. They're a neutral third party. Listen to them, and then and in this situation, this guy, we did 3 different mediations. You have 3 different external people in addition to 2 attorneys that served on your team to tell you. And I remember the judge saying, the mediator asking, "Let me ask you, worst case scenario, what happens? You walk away with zero? Oh man, I would be devastated. Oh, I don't even know if I can live after that."
Oh no. Yeah. And walked away with zero.
And I can only imagine the stress levels, the tension in the household. He had a kid going to college. Like, you know what you could have did with that money?
Yeah. Yeah. Yeah.
Yeah. And so you understand, it just brings more tension within your household, the stress of you reliving that over and over again. Like, I wish I would have said this on the stand. I wish I would have did that. Or I wish I would have took the money when it was there. You have to live like that. And so it's a lot. It's a lot. And that's
Yeah.
why ultimately I have to charge for a retainer up front.
Yeah. I'll say too that, Attorney Hall-Jackson and I are talking about, like, take the advice of your attorney. And it's so important that as you're choosing an attorney, you're choosing an attorney that you trust,
Hmm.
whose advice you can trust. A lot of people just kind of pick the first attorney that calls them back. And okay, but it really, like, the vibe that you have with the attorney really matters. Feeling like you're seen with your attorney really matters, because that way down the road, when maybe they're giving you advice that's difficult for you to hear, you can at least rely on the fact that you, at the beginning and throughout, have trusted this person, that you actually feel like they have your best interest in mind, that they're not trying to get out of the hard work, that they're not, treating you differently
Yes,
because of your financial circumstances, all of those things. So it's just really important to vet the attorneys that you're talking with, talk to more than one attorney before you pick the attorney that's going to represent you. Make these attorneys earn your business, because that's our job, is to earn your business and do the best that we can when we're representing you.
I agree.
Thank you so much for this conversation. The final quick question that I want to ask you is around preparation, or not even preparation, considerations. What considerations should somebody make before they decide to go down this potentially year-long path
Years.
of holding an employer, right, of holding an employer accountable?
The main thing I would tell people to take in consideration: what is the harm? Like, are really the same thing. If you ever watched the movie by Tyler Perry, Why Did I Get Married? The first version, where Janet Jackson gave advice to her 2 girlfriends to take a sheet of paper and simply draw a line down the middle. The pros and cons. What are the pros and cons that I'm going to get out of this if I bring it? And ultimately, you have to be thinking bigger than yourself. I know it's you who's
Mm,
sitting in the seat, you're suffering, but I always tell people, think about those who come behind you, because if you bring a frivolous claim and it's not substantiated, you only make the claim, you only make it worse for the next black person that comes to the door. So, or the next person in your protected class that comes to the door. So, you want to make sure that you are bringing the right claims. And so, one, what is the harm? What has actually been done? Is my feelings just hurt, or did something actually monetize wise, they took my benefits away. They did this to me. They did this. Now I'm so entrenched in this that I have to go to therapy twice a month, every week in a month. What is going on
mm,
that I can say that the harm has been done to me? And then most importantly, the action. What is the action? I had a client, well, a potential client call me, and I've been trying to help this guy find something because his medical record shows that it's definitely declined his health, and that he was definitely in some kind of hostile work environment, or something was going on in that work environment where you got this perfect bill of health, and so now you're abusing alcohol and drugs. something was going on. But every time I ask him, the things that he's telling me is so trivial, and I don't want to seem offensive to his experience. But I'm
Mm-hmm.
trying to tell him, just think of it as your kids coming home to tell you this happened to their on their day. What is your response to your child? You got some parents go hit the kid back. They hit you or they called your mama or whatever. You go say it back to them. And so, is it as simple as having a conversation and talking to this person and say, hey, you have offended me, and I'm asking you nicely and politely not to say this to me again, not to treat me this way or do this? Or is it worth the idea of, I have tried this already, and so now I need to get a third party involved, and let's see if we can do, I would say, start with mediation. And in most situations, if you go to any of these venues, one of their process is to offer mediation right away. Now, of course, both parties have to agree, aka your employer and yourself will have to do it. But I want you to take those things into consideration. Is it just something that I'm just butt hurt and my feelings are hurt, I'm embarrassed, or was there some actual harm? And then what was the action? She's always over my shoulder. Every time I do my work, she's questioning it. That's not enough for a lawsuit. I'm sorry. It might just be a sign that it's time for you to exit and start job searching, or see, can you
Mm-hmm.
bid off from under that supervisor to a different shift, to a different department? So what are your options here outside of litigation? So those
Mm-hmm.
are main things: the action and the harm, and then the length of time for litigation. Even though we have a limited package and we got a full package, on average you're talking about 90 days for a limited. You gotta realize that I gotta learn your facts, draft up a letter that's gonna at least take 30 days after you retain us. Then I have to send over a demand letter and see if they're going to engage me. And some employees are like, look, we wanted this person gone this bad. They want to be gone. Look, here's something. And then we negotiate until we meet. Or some people like, we don't think we did anything wrong, or we're going to fight this tooth and nail. And so
Mm-hmm.
then, until they get an attorney involved, and their attorney like, it's just not worth my cost for you to continue to fight this based on what they're asking for. And so understand that it's an investment, and as you have to relive and recant these stories to
Mm-hmm.
me as the attorney, you call in other law firms to give various opinions and consultations. Then once you finally get in litigation, you have to tell the judge, the jury, the court reporters in these situations, like, you have to tell the story repeatedly. And I guess so many people that shut down. I know you haven't heard from me, but it's just a taxing and emotionally tolling on my body
Mm-hmm.
to tell you this story over and over again. Then there's a discovery process where you have to put it in interrogatories. You have to now
Mm.
go print up all those emails and forward it to your attorney office. Can I mentally handle this, or is it best for me to just resign and go about my business and find another
Mm-hmm.
work environment?
Yeah, or negotiate a mutual
So
termination, and get a severance.
yeah, you
You
can
know,
always get a severance. I always tell people you need something to leverage. This is a good ending point. You always need something to leverage a severance. You can't just say, now,
right?
granted, you can always say, look, I want to leave here, and here's my 2 week notice, and here's what I'm asking for. Feel free, throw it out there all the time. But in order for an attorney to take on your case and negotiate a severance for you, we have to leverage, aka threaten the idea that we have reviewed this case and we find it that we would be successful if we were to pursue this in litigation. And here are the claims. We feel like there's a hostile work environment. We feel like this is race discrimination. We feel like it's age discrimination. And if you guys don't agree with this, now you're going to have to deal with me longer and pay me more, right? And
Right.
so that's what a severance is. And so here's the kind of things we're asking for. Instead of a termination, we want a resignation. We want a neutral reference. We want this, we want that, we want that. And usually the parties can agree on each other's terms. Usually, like I said, just as much as you're sick of them, they probably sick of you with coming to complaining and, telling on these
Yeah,
people, sending emails, causing trouble in their eyes. So they're usually open to, let's shake hands and get out of here.
yeah, and be prepared to sign a non-disclosure
Oh,
agreement.
yeah.
So
Definitely
don't.
confidentiality. That's
Yeah.
that's another benefit to the defendant, and ultimately you. But what they're trying to disguise and hide when they say confidentiality is really the dollar amount. They really want a dollar amount. If I gave you a lump sum, I don't want you going around telling everybody in town, including your co-workers, that we paid you X amount of dollars, because now everybody's going to sue us trying to get this money.
Right.
The only other thing that will prevent you is a non-disparagement clause, which says that you can't now go blabbing to the news and everybody else in town that's willing to hear what these horrible work experiences was for you. So that's the only other
Right.
thing. Some of them I have
Right.
probably had like one where they didn't put it in there, and I damn sure didn't remind them that they didn't put it in there about the non-disparagement clause.
Yeah.
And then one, I was trying to negotiate it, and the nuances. I'm like, well, I want her to at least be able to talk about it. This is. They like, look, we're just gonna alleviate it and just get rid of it, altogether.
Oh, they weren't concerned at all.
They wasn't concerned at all, so they just left it
Okay.
alone.
All right. Thank you so much. Can you remind us the name of your book and where we can purchase it at? And then also the name of your firm, if folks want to seek you out. And do you practice only in Illinois or do you practice nationwide?
I can practice federally in
Right.
all 57 states because I practice under federal statutes. And so
Okay.
that's that. So my license is in Illinois, and by most the EEOC is in every state, so I can
Right.
bring your case in all 57 states. With this, I'm saying 50.
We gonna be all right. Yeah, I can see it.
So I said 57 states. It's 52 if I'm not mistaken.
Yeah, I was like,
Let me get it. It's 50 states with the two territories, Puerto Rico and Hawaii. They done took over
Yeah.
Hawaii and Puerto Rico.
No, Hawaii is a state.
Yeah. I'm trying to see what
Okay.
the other one. Yeah. So no, they now a state. They
Yeah.
consider themselves territories because they really don't want to be a part of the US. That's why I said it that way. Here we go.
Thank you. Okay, so she's showing her book, We Gon Be Alright. Awesome.
And it's called, the subtitle is A Black Executive Guide to Navigate Workplace Dynamics. And ultimately, it pretty much, like I said before, it's a guide on what to do before you decide to sue, and if you decide to sue, the things you need to do, which usually includes document. There's so many people that this happened. Oh, I got locked out of my computer because they terminated me. No, start pulling that stuff now. When they start bothering you. If this email was offensive to you, print it up or forward it to another email account, so when in the worst case scenario you do get terminated, that you have access to that.
Yeah. Awesome. And where can we find you?
You can find me on all social platforms at Blow the Whistle Law, or under Chiquita Hall-Jackson.
Awesome. Thank you so much, Attorney Hall-Jackson. Thank you so much for listening to Impostrix Podcast. I appreciate your support and that you continue to listen week after week after week. I've got some exciting news, which is that you can now listen and support Impostrix Podcast on the Alive Podcast Network app. You will find ad-free listening to nearly 100 other Black-hosted podcasts, in addition to Impostrix Podcast, and you'll be able to support those podcasts and really kind of get into your groove with that app. I hope that you will join me over there. I appreciate your support. To connect with me, feel free to join me on Instagram at Impostrix Podcast. You can also join me on Facebook in our validating space. Just search for Impostrix Podcast. All right, until next time, be validated.